Are you looking for top secret city reports or maybe how much the mayor makes? Well, if you're in Utah, you're in luck. I'm Jacob Hansen. I'm a land use consultant and I have a law degree from BYU Law School, and we're going to be talking about how to take care of grandma. Not that grandma, the Governmental Records Access and Management Act. Basically, it's a public law that allows the public to request and receive public records from government entities in Utah, and we're going to be focusing on the rules for cities. So this is really important if you work for a city, because obviously the public will request records from you and you have a duty to give those records with certain parameters. But it's also important if you're a developer or a private citizen. I mean, sure, you may want to just check up on the city, make sure it's being fiscally responsible and so forth. But as a developer, you might also be curious what kind of reports the city is getting, or maybe you need minutes, or maybe you need a certain report that the building inspector did when he inspected your parcel or something like that. Well, you can get that sort of information. So listen up, we're going to go through the basic rules of grandma requests. And I will warn you, it's not easy and it's not that interesting. So when in doubt, make sure you ask your city attorney, or if you're a developer, your own attorney, or look up the statute at least, because we're going to go over the basic rules, but there are a lot of them. Okay, so what counts as a public record? This is the threshold question, because the basic rule is that if you ask for a public record, the city has to give it to you, and they have to make it reasonably easy for you to get it. But there's a big question about what counts as a public record versus a private record, and really you just need to use common sense. Okay, personal information that just probably shouldn't be disclosed to the general public, that's going to be private and it's protected. And then pretty much everything else, and importantly, all sorts of development related information, that's public. And that's probably what you're looking for anyway. But just to be safe, let me go over a list of the type of information that's private and not subject to release. Security records, such as passwords, badges, security schematics, or building layouts, because we don't want the terrorists to know what your city hall looks like on the inside. Employees, social security numbers, unemployment benefit records, tax information, marital status, driver's licenses, you get the idea. Personal notes or communications from the government employees, so like the city clerks, personal text messages or post-it notes, or even personal calendars, emails, notes, letters that the government employees receive that are personal in nature and unrelated to the government duties, those are protected. Also, confidential information with your attorneys, or if there's a closed public meeting, those minutes and records don't need to be released. And finally, junk mail. It's a small thing, but if you're a city clerk and you're worried about throwing away those ads, just toss them. Here's a list of some things that are considered public records, and again, just use your common sense. If you think it's something that the public should know and there's really no private interest that would be jeopardized, you can probably ask for it. But there's a long list in the state code. Okay, so for example, records that are filed with the government, like property records or, plats and that nature, those are obviously public. Ordinances and resolutions of the municipality, those are definitely public. So are minutes and reports that are submitted along with those minutes, or that the city council or the planning commission hear in a public meeting. Basic information about city employees is also public information, such as their compensation, their names, their qualifications, and their contact information, but not their social security number. Also, receipts and contracts from purchases from the municipality and contracts that it enters into, those are public records. Summaries of voter records and financial statements, so you can make sure the city is on the up and up. Okay, so once you pass that first threshold and you know that what you're asking for is a public record, it's a development agreement or something like that, you can get it. Again, the basic rule is the city has to give it to you, but you have to submit a request. You got to ask for it, and your request has to include some key information. Number one, your request needs to be in writing. Oral will not do, phone call will not do, it needs to be in writing, email, letter, messenger pigeon. Your writing needs to include your name, your mailing address, your email address, if you're okay receiving it by email, your phone number, and a specific description of what it is you're asking for. If it's too broad, they don't have to give it to you. If it's just like, please give me all your records of all time, no. Tell them what you're looking for, what you're really looking for. Also, you got to send this to the recorder's office. So typically, this is just the city recorder. Look them up on the website, send it to their office, your request. Also, the record needs to be something that currently exists. So don't send the recorder a request for all meetings of the city council in perpetuity, because that's just not fair. It has to be a record that has already been produced, and then if you want next week's minutes from the city council emailed to you, then you're going to have to file another request next week. Requester beware, we'll say. Do not become what they call a vexatious requester, which is someone who is constantly spamming the city for all sorts of records that they don't even really need. So if you're asking for 1,000,000 records and you become this vexatious requester, you're just bugging the city. Maybe you have a vendetta. I don't know. I don't judge. But if you become that person, then you can have your rights revoked. So you can lose all record privileges, and grandma will not smile upon you anymore after that. If you're on the government side, the city side, and you get a request, here's how you need to respond. First, public records are property of the state, so don't destroy them, okay? I don't know what you have to hide, but the cover-up is always worse than the crime. First, you got to decide whether it's public or a private record, and once you decide that it is a public record, then you can charge a fee, because your time is valuable too. So you can charge a fee for the retrieval or the production of a document, but you can't charge a fee just to have the person show up at the city hall. So honestly, maybe they want to come look at a big map in the city hall. You can't charge them just to step in the door. And if they ask you for 10 documents and they don't want them emailed, they want to show up and like go through them, then you can charge them for your time as you gather the documents and put them in a folder and hand it to them. But you can't charge them just for being there physically at the city hall. You can't charge them for something if it takes less than 15 minutes for you to do it. And if you're going to charge a fee, it has to be a reasonable fee and for your actual costs. So you can't just be like, well, it takes me 20 minutes to get this record. We'll bill them for an hour. It sounds good. No, it has to be actual costs. We're trying to make this easy for people to get records that they are entitled to. Another rule here is that if you're going to charge a fee, part of the reasonable part of it is that you have to bill it to your lowest paid employee who's capable of getting the record. So for example, if someone emails the city recorder and says, I would like to review 5 contracts that the city entered into, the city recorder, or maybe the city clerk, whoever has access to these documents, can pay for her time to get the records and produce them. Maybe it takes 2 hours, and maybe the employee's billable rate or hourly rate at the city is $25 an hour, so it's a $50 fee. That's fair. But you can't assign that task to the city attorney, because maybe you hate the requester, and have the attorney bill their $500 an hour rate. And so what could have been a $50 fee turns into a $1,000 fee. That's not fair, it's not right. All right, so once you get past the fee part and you've decided that you have a record that belongs to the public, you have to follow a timeline. So there are deadlines that the state law imposes, and your city might actually have shorter deadlines. That would be a question for your local ordinances. But at least as far as the grandma statute is concerned, the city has, as a baseline rule, 10 business days to turn around and produce the record. 10 days. Now, if someone requests the record be expedited, then the city only has 5 days. So the city technically can deny the request to expedite if, maybe someone's borrowing the record or it's just impossible to get it in that time. But as a general rule, you look at the request. If the request says, please expedite this, I need it right now, then you have, as a city, 5 business days to produce the record. And if you can't, then, or if they don't ask for it to be expedited, then you have only 10 business days. So sooner is better. All right, now what if you want to deny a record? Let's say that someone requests a bunch of tax voter information and you are correctly assuming that this is private information. Well, the city can deny a records request, but if the city is going to deny a records request, you have to actually respond to the applicant and tell them a couple things. First, you have to tell them you denied the request and you have to specify what parts of the record you denied. Then you have to tell them why you denied those parts, and you have to cite to the state statute that allows you to deny the request. The baseline rule is that you have to give it to them. So if you're going to deny it, you have to be like, oh, here's an exception. This is a private record. Okay, and then the third thing is that you have to give the requester information about how to appeal your denial. So if the person says, I'd like X document, and you say you can't have X document, it's private, you would say, here's the state code for why we can withhold it. And if you think that I made this decision in error, please appeal it through this appeal process. Speaking of appeal processes, this is a sticky issue. So as a city, you really need to have your own appeal process in your local ordinance. So your local ordinance should specify what to do with records requests when they are appealed, the procedure, and also who your appeal authority is, who the person should be submit their appeal to, the requester should submit their appeal to. If you have those two, then you probably have your bases covered. But if you don't, then there is another government entity. It's the Government Records Office. It's an entity owned by the state that kind of is like a middleman. So as a requester, if your application gets denied, your request gets denied, and you want to appeal, the first thing you have to do is go through the local appeal process. Go to the appeal authority, Follow the procedure. There could even be multiple layers of city appeal. You could have 2-3 layers before you get out of the city, but you got to follow that process. If the city does not have a local appeal process and authority established, then you have to go first to the Governmental Records Office, and then you can pursue litigation. Now, if the city does have a local appeal process, and as a requester you go through all of that, then you can bring the matter to court. There was actually a case about this specific requirement that made it all the way to the Utah Supreme Court just in 2024. So this case, I was actually privileged to watch the oral arguments for this case because at the time I was an intern for Chief Justice Durant. And it was a very interesting case. I'll spare you the very boring legal details, honestly, but it came down to procedure. So what happened was it involved Herriman City. And this guy emailed the city the day after Christmas Eve. And he says, I need a bunch of documents. I will be in the office tomorrow, so the 27th of December, to inspect the documents. Please have them ready. The city replies correctly and says, hold on, we have 10 business days to respond to your request, so don't worry, we'll get them ready, we'll give them to you in 10 business days. And by the way, here's a $250 application fee because we think it'll take us 5 hours to produce the records. So the attorney, rather than going through the local appeal process, because Herriman City did have an appeal process, this person immediately the next day filed a motion in court. And so this whole case goes up to the Utah Supreme Court, and it boils down to, did the attorney follow the local appellate procedure? And he did not. So this guy actually lost the case, even though he had a lot of great arguments about, maybe why he didn't have to pay a fee or why he didn't have to wait 10 days. The moral of the story is he lost because he didn't follow the appellate procedure on the local level. Best practices for cities. First, there are a lot of documents that honestly you should just have on your website. No one needs to request them. If someone does, you can just point them to the public website. Things like your ordinances, your resolutions, your general plan, and your zoning map. You should also have on your website, or at least available in the recorder's office, a grandma request template. Just a form that people can fill out that makes sure that they get all their information that they need to submit, that, so that they describe the items in detail so that you know what to request, and so that they feel like you are complying with the intent of this Utah statute. Also, don't destroy records. I don't care what you're trying to hide, but the cover-up is always worse than the crime. So just keep the records on file, keep them longer than you think you need to. If you are a requester and you want to know what the city's up to, you can. But you need to request all the necessary info, so make sure that you're asking for what you need to, and think about what you actually need. Don't ask for 1 million documents if just 1 or 2 will do. So maybe take a minute and just think about what is it you're actually looking for, and if you can narrow down your request, it's going to be a lot cheaper for you and a lot easier for the city to get it to you. Especially this is important in small towns because even if they are trying to follow the state code, sometimes they're just understaffed and they're trying their best. So try to work with them a little bit. Special thanks to the Utah Property Rights Ombudsman for sponsoring this video through their Land Use Training Fund. It's a fund that collects a surcharge on building permits in Utah and then uses that to produce educational content so that you can know your land use rights in Utah. Thanks for watching.